Here's part of the problem. Your attorney is trying to save you. Oh, you know what? Don't throw your hands down. Bond revoked. Adjourn next week. Take him.
What you're about to see proves that some of the biggest courtroom blow-ups don't happen during major trials. Sometimes, they happen in routine probation or bond hearings where a few bad decisions can change everything in seconds. In the first hearing, the judge is clearly trying to help the defendant avoid jail after concerns come up that he may have been close to the alleged victim. The instructions are simple, and even the defense attorney seems to have worked hard behind the scenes to keep the situation from getting worse. But instead of listening and moving on, the defendant keeps talking, questioning the court, and slowly making things harder for himself. Then the second hearing takes a completely different turn. A defendant accused of aggressive behavior during a community corrections intake explains that mental health issues and stolen medication may have played a role in what happened. At first, the judge appears willing to hear him out. But once the interruptions start and emotions take over, the mood in the courtroom changes fast. The truth is, court is not only about what you say, it's also about how you say it. Respect, patience, and self-control can make all the difference. Watch closely, because both of these hearings show how quickly a calm courtroom can turn into serious consequences.
The case, People versus Lawrence Buckner.
Done on behalf of the people, Your Honor.
Your Honor, my client just stepped out in the hall. I'm just having
No.
Thank you. Chris Crowder, on behalf of Mr. Buckner. And Assistant Public Defender Jay Bellinger on behalf of Mr. Buckner, who approaches.
Your name?
Say your name.
Lawrence of the family of Buckner.
Your approach.
You may. All right. Record should reflect in the bench conference in this case. Starting with the case ending in 0446, there's been an amended complaint filed. Counsel has indicated
Yeah, we will waive a formal reading stand new to that, Your Honor.
then in this matter, it will adjourn it. So it will adjourn both cases out to the 21st, May 21st, 2026, 9 a.m. At this moment, found will continue. Mr. Buckner, sir, I've gotten a report, and there are some reports that you were in the vicinity of the victim in this case. All right. Sounds to me like it may have been that you were there. She may have showed up in the area or whatever. I'm not attributing any ill will to that. I'm just going to inform you that you happen to be up. You're required to leave, okay? Be in that area. Am I understood?
I was at work.
Just say yes.
Okay, is it outside of the work? Is it outside of work, Mr. Simpson? Because honestly,
Mr. Buckner.
yes.
Ah, come on, man. Just say yes. Your attorney just talked you out of jail. That's what that bench conference was. Your attorney did a great job. All you have to do is say yes, ask all your questions to your attorney. It's never this simple with Lawrence of Family Buckner.
Because you don't
Honestly,
shoot
yes.
yourself in the foot right now.
He's giving you. Say yes.
I said, I understand that, but I'm asking about work. Mr. Simpson, is it also include work?
I have two ways that I can handle this. All right. I am not handling it in a way that is the most harsh. I told counsel that I would give you that admonishment. All right. There's a circumstance where you're legitimately there. Talk to your attorney about that. Okay. And they will be able to advise you what you should do in those circumstances. I am giving you my warning. Right? Am I understood, sir?
I heard exactly what you said. So you told me to ask my counsel if I have any questions in regards to being justified at any location.
Stop there.
That's what he asked me. I'm just showing him I was listening.
Just say you understand.
Yes.
Right. Thank you.
All right.
All right. What else?
That's it.
Oh, I didn't know if I was dismissed here. Thank you.
You will let him know I could have handled that very differently.
I'll drive.
Oh, okay, thank you. All right, that's it. No more Mr. Nice Guy. Sorry for everybody else.
Excuse me, I'm trying to talk, sir. I am trying to talk to you.
Here's part of the problem. Your attorney is trying to save you. Oh, you know what? Don't
At
throw your
first,
hands down.
this
Bond
hearing
revoked.
seems like a
Adjourn
normal
next week.
probation violation
Take
case,
him.
but the pressure in the courtroom starts building almost immediately. The court is reviewing claims that the defendant acted aggressively during a community corrections intake, to the point where staff reportedly needed extra help to handle the situation. From the judge's voice alone, it's clear this is being taken very seriously. The defense tries to explain the bigger picture. They mention mental health struggles, missing medication, emotional stress, and even a written apology from the defendant after the incident. In many cases, judges are willing to consider factors like these carefully. But courtroom situations can change fast when emotions get involved. The moment a defendant appears argumentative or unwilling to listen, explanations can start sounding more like excuses. And once a judge feels that courtroom instructions are being ignored, the focus quickly shifts from understanding the situation to holding the person accountable. What you're about to watch is a clear example of how fast courtroom patience can run out when communication falls apart.
Thank you, Your Honor. Alex Warren on behalf of Mr. Hill. Mr. Hill, can you state the court?
Jose Rafael Hill, good morning.
Good morning. We're going to need to deal with this violation.
Your Honor, I reviewed that with my client. At this time, he's going to admit to not only his behavior towards...
Why was he acting that way?
Oh.
You're going to have to give me an explanation for that. Those folks over there at Community Corrections have to deal with a lot of people coming through, a lot of people that are under stress, and they don't need this garbage. And certainly, and I'll be honest with you, especially Ms. Dozier, does not need this garbage. So before you start talking to me, you better make sure you understand what you're saying to me.
And, Your Honor, before the violation issued, right after the intake terminated because of behavior at the intake, Mr. Hill came to my office.
We're clear. It's not just his behavior. She had to call officers in, try to deal with it, and still tried to do it, and he still didn't do it, and he didn't complete his intake. Go ahead.
My office made me aware of what happened. Sat down with me, wrote an apology letter to Agent Dozier, sent it to her. I extended my apologies on his behalf. And I think to try and put this into context, and he acknowledges there's no excuse for it, but to try and put it into context, Mr. Hill has had medication stolen. He's prescribed medication for a mental health diagnosis. As he scheduled 2 appointments with his psychiatrist to make a plan moving forward. And after sending our apology letter to Agent Dozier, one thing Mr. Hill brought up was if his social worker was present at the time of intake, I think that might help him regulate his emotions, but he's still trying to get back on the medication that he's prescribed. So
We'll just read the letter here.
Well, Your Honor, I can answer any of the court's questions, and I think Mr. Hill can answer any of the court's questions as well at this time.
Please, I will answer. Please. Thank you. This is difficult. What's very difficult? What's going on? But please, I will answer whatever you need to know from me over here.
Over here.
I did not expect to go to that meeting and that happened. That's for sure. I'll be open. I'm an open person. And I was just opening up to Miss Dozier about my...
No, you weren't. You were interfering with the intake process. She was just trying to get certain things done.
Can I mention something?
Go ahead.
I I was talking to Ms. Dozier in a meeting, and there was some confusion. I was confused, and I was explaining to her why. Because the magistrate informed me that if I go to when I go to community corrections, because he ordered me to go there, and I did everything he told me to do. And when we were in court, when I was in jail, and we were in court, he mentioned about corrections, and I already have past experience with community corrections, so I understand that these things cost money. And excuse me, please, I'm not interrupting anyone, and I don't do that. So if I do, sorry. But once I was ordered to go there, I mentioned the judge in court. I said, Judge, I do not have any money. I just do not have any money, Judge. And he said, that's okay. Community corrections will not turn you away if you do not have any money. So when I went to community corrections and met with her in her office, I mentioned that to her. Because she mentioned that, I asked her, is this going to cost me? And she said, yes. And I said, okay, well, I don't have any money. And she mentioned that, excuse me, I'm trying to talk, sir. I am trying to talk to you.
Here's part of the problem. Your attorney is trying to save you. Oh, you know what? Don't throw your hands down. Bond revoked. Adjourn next week. Take him.
Your Honor, we can come back next week on that.
Yes.
I appreciate that.
Oh, you better keep moving. I'll adjourn this out to the 14th.
Appreciate that, Your Honor.
And right there is the moment this hearing completely falls apart. Up to this point, the defense attorney had presented a story that could have earned some understanding from the court. Mental health struggles, stolen medication, emotional stress, and attempt to apologize are all factors judges may consider when handled the right way. But everything changes once the interruptions keep happening. From the judge's point of view, the issue stops being about confusion or personal struggles and becomes about behavior inside the courtroom. The focus shifts to whether the defendant can follow instructions, stay calm, and respect the court's authority. And that matters because bond revocation is serious. The moment a judge believes someone cannot comply with court rules or maintain control, taking them into custody becomes a real possibility. That's why you suddenly hear the judge move from trying to understand the situation to ordering the defendant removed from the courtroom. These hearings are a strong reminder that courtroom behavior can be just as important as the legal defense itself. Staying calm and respectful can help your case, but arguing with a judge usually makes things worse. Now, it's your turn. Do you think these defendants were misunderstood, or did they create bigger problems for themselves by continuing to argue? If you found this courtroom breakdown intense and eye-opening, make sure to leave a like, share your thoughts in the comments, and subscribe for more shocking courtroom moments and legal analysis.